Our final speaker this morning is Christoper Hudson. He's our keynote and will deliver an address. I think it's an interesting point of departure for Christoper to come in here after that, looking at the digital sphere. And Christoper has a background that I suppose is what people would have for a long time considered the traditional mode of using images outside of a gallery, and that being publishing. Christoper is the publisher of the Museum of Modern Art in New York. The museum publishes scholarly texts, exhibition catalogues, and print and digital publications for the general public on modern and contemporary art. From 1986 to 2005, Mr. Hudson served as the publisher for the Getty Museum and Trust and developed several hundred titles in the fields of archaeology, antiquities, conservation, and the fine arts. He's currently chairman of the International Association of Museum Publishers, president of the International Federation of Scholarly Publishers, and a board member of the Motivron Group of International Publishers. Please welcome Christoper Hudson.
Well, thank you. That's much better. Thank you for the organizers for asking me to speak. And after 4 great presentations, to subject you now to a 50-minute further presentation is ludicrous. I mean, it's the sort of thing reserved for communist dictators' speeches. So I'm going to divide it into 4 sections, because I know we have a mixed audience here, and I'm doing that in the hope that not every section will be completely boring to every segment of the audience. So this is, despite 4 parts, there is a signature image to the whole thing, and this is the signature image, which is the tritest and most simple of all, the eternal verity, which is that no matter how much arts publishing or the landscape of arts production and dissemination changes, there is still no such thing as a free lunch. Tristan initially asked me to talk because of a speech I gave to the International Publishers Association last year about managing imaging rights, of course from a publisher's perspective, and that was to a publisher's audience. And I will talk a little bit about the publisher's process in part 1 of this. But he also asked about fair use. In fact, everybody this week in Australia has been asking about fair use. So that will be part 2. And then parts 3 and 4 are an attempt to hit some broader themes. All right, we're in a visual age now. All publishers, all content providers really have to add visual competency to their other skills today, because images are central to all communication today. And in our case at MoMA, we are both publishers of works for which we seek to obtain images to use in publications, and we often get very frustrated at how difficult and time-consuming and sometimes expensive that can be. But at the same time, we're grantors of licenses to images, and we're also copyright holders or stewards of copyright for certain artists. So we're a bit schizophrenic about it. And as the program notes said, depending on one's particular business, your attitude towards image rights gets shaded one way or the other. Right. People care about what's important to them, and that usually means, or often means, what's monetarily important to them. That's pretty basic, you know, that's pretty obvious. But it's worth mentioning, it's worth remembering, I think, because a lot of the public policy discussions of advocacy about image rights is couched in terms of the public good. And it's healthy, I think, to scrutinize, or at any rate, let's say, not to be too naive, about the degree to which that advocacy is purely altruistic or the degree to which it's colored by business interest. So the first thing to say about managing imaging rights well is that it can be a maze, it can be a labyrinth. And since this is a sort of dry subject, I thought I'd try to show you some art as I'm droning on about the boring parts of this. This is work by an artist called Elizabeth Murray. She did it, I don't know, 9 or 10 years ago, just before she died. It is a maze, it is a labyrinth, it's an enormous oil on canvas on woodwork. It's a very big work. It's called Do the Dance, because that's the Ray Charles record that she was listening to when she did this work. Anyway, there's a very good reason why it is such a maze. There's a very good reason why images, for example, were left out of the original proposed Google Book settlement. A novel may just have one copyright holder. A visual arts book may have literally hundreds of copyright holders. And I have to say that some of my colleagues in commercial publishing, who quite properly, vigorously defend their own copyrights when they're assailed, sometimes get a little schizophrenic when they're confronted by this daunting job of clearing all of these rights for a visual book. And that's when we start hearing, well, you know, all images from all museums should be available free everywhere in high resolution. And that's the other side of the same coin, though. While simplifying things is a very laudable goal for everybody, like most sound bites or simple declarations about images, about any copyright issues, actually, it ignores some very real complexities and real costs. So one of those complexities is that there may indeed be multiple image rights holders for a single image. There may be trademark considerations, obviously. There may be building rights as well. You know, Disney has building rights, so does the New York Stock Exchange. There are, of course, the photographer's rights. There may be personality and privacy rights. If there were an identifiable human being in this picture as well as Mickey Mouse, those rights might come into play as well. And although others may simplify, and we heard a lot of very good stuff from Melissa about this, the Instagram thing, for example, Instagram may say, based on your tacit acceptance of their terms, that they have the rights to use in any way they want an image that you post. But that might not, at least in theory, stop you getting sued if the image you've posted has third-party rights holders in it. And then finally, yes, there's the right of the asset holder, there's the right of the person who took the photograph, which may not be an individual photographer, maybe a museum's expensively maintained imaging department. There's the right to charge you a fee if you want to use that particular image. So that's one set of complexities. Then there's the very basic point that ownership of the work of art doesn't equate to ownership of the underlying copyright interests. And it is surprising how often that is not understood. When an artist sells his or her work, he doesn't give up the right to reproduce it. If you own a work, you can show it where it's located, you can lend it to another venue, you can sell it, you can donate it, but you can't make copies of it. You can't prepare derivative works from it. You can't distribute copies to the public or display or perform the work. Only the artist or the artist's representative can do those things. So a museum cannot just give images of the works in its collection away if it hasn't acquired the rights from the original copyright holder. The artist has those rights, and that's true pretty much worldwide, despite copyright law variations. Okay, so on the left, Queen Anne, who started all of this in 1710 with the first copyright statute. And most of the Anglo-American law is derived from that. There are variations in national laws. Moral rights are stronger in Europe, and especially in France. And actually, they're stronger in Australia than they are in the US already. And indeed, the divergence between the Anglo-American concept of copyright, which has tended to see culture more as a commodity, from the French concept of the rights of the author, the rights of the artist, natural human rights, protecting the creator, might be said to go all the way back to the beginnings of copyright law. And what you see on the right there is an image of Henri II, who granted the first, of course it's not Henri II, it's a very young Roger Moore playing Henri II in a 1956 movie, and that's Lana Turner playing Henri's mistress on the other side of the image. But it was Henri II who in 1551 granted the first privilege concerning publication rights to his lute player. So back to copyright variations between countries. National variations, such as on term of copyright, do complicate things when it comes to image research. But a more problematic thing, in my experience, is the competing assertions you sometimes get. For example, in Venezuela, the government asserts copyright in a lot of art, but the heirs of the families that created that art also assert rights. That's kind of complicated and problematical. You find yourself paying two different people for the same work of art. As Oliver reminded me yesterday, I have this sort of rule of thumb, which is a bit flip, but there's some truth to it. My advice to visual arts publishers is usually deal with the old masters if you can, because they're in the public domain. If you can't deal with the old masters, deal with a living contemporary artist, because then maybe you can talk about the art and how to publish the art and its meaning and how best to disseminate it. But the worst thing is to deal with the recently deceased artist. That can be an absolute nightmare. So, how do museums that are in the image business deal with all of this? Well, not much by fair use. We use non-exclusive licenses. And we use what we call blanket agreements, negotiated agreements. And that saves an enormous amount of work, because managing image rights is not just about money, it's about time and resources and staff time. A non-exclusive license is something that we always seek when an artwork comes into the museum. And this simply says, we don't want any exclusive rights, we don't want you to assign copyright, we just want to be able to reproduce the work in our books, on our websites, in our publicity, without coming back to you every single time. And a negotiated agreement with an artist's rights agency says, we'll pay you up front a lump sum, in our case we do it every year with a couple of agencies, in order to be able to reproduce all of the work of all of the artists you represent, whether in print or in digital. It isn't necessarily inexpensive, but it more than pays for itself from my point of view in reducing complexity and time and workload. Museums maintain huge databases with all the image information and different language and territorial rights and digital versus print rights information and proper expert-approved editorial captions, any restrictions and credits, any requests from the artist for fees or requests for complementary copies or to review color proofs. It's a lot of work managing that complexity, and of course publishers who do the occasional book can't do all that, but to do serious scholarly visual arts publishing does require that sort of investment. There are four main sources of potential images for most people intending to use or publish pictures. We've talked about how institutions may charge asset fees, and yes, it is true that sometimes agencies can be expensive. We've talked a little bit about how the last category, the artists, but also the estates and the private collections can present their own demands and problems. But in our experience, all of those categories, all of those relationships are important, and those sources, rather than the web, are far more reliable, despite the hoops and despite the fees. The web, of course, is the simplest, most ubiquitous and tempting source to use for images. But there are real digital pitfalls. It's easy but dangerous to use images off the web. Images on the web without a copyright notice are, of course, not necessarily public domain. Many of them are not public domain. Remember that the Berne Convention, to which Australia is a signatory, does not require a copyright notice. The default is that the image is copyright. Not charging for an image has nothing or has very, very little to do with whether you can use it. Just because it's posted means nothing. And I say all of this because small publishers have on several occasions been severely damaged and in at least one case I can think of put out of business by lawsuits for copyright infringement using images off the web. And the possibilities in the digital realm of indirect liability and the as yet unclear resolution of first sale and resale, those are other potential pitfalls. So that's part one. It's really complex. And with all of that complexity, you would think that a simple, broad, expanded, fair use doctrine would be devoutly to be wished for by any right-minded person, right? Well, so this is the guy whose wish to the genie was to get $1 million. This is from an insurance company commercial. I've got to do proper attribution. It's a Geico insurance commercial. So he wished for $1 million, and this is his house after he got his wish. So be careful what you wish for. That's the sort of theme of this part two, which is about copyright landscape and fair use. You know, who could be against helping out budget-strapped school districts and libraries and educators? Because that's the only sort of thing involved in fair use, right? On the other hand, who could be against giving a living wage to a starving artist up in her garret? Because that's the only sort of thing involved in defense of copyright, right? One of the downsides of the current interconnected but fragmented age that we're in is the extreme polarization that comes with a soundbite approach to the media. And then when you take objects like copyright exceptions and you ask a lawyer or even worse, a publisher to talk about them and to talk not about the headline-grabbing extremes but about the day-to-day realities that involve, well, you know, moderation and consensus, they're not very sexy. They don't grab people's attention very much. But that is what you're going to get from me for two reasons. First, I work for a tax-exempt non-profit, and it's not appropriate to lobby, only to observe. And secondly, I should not dream of pretending to understand the local complexities. What I can do, though, from my work in the US and with the International Publishers Association in Geneva, is to give you a rundown of recent and pending issues to do with fair use around the world. From my point of view as a publisher of what I hope are visual arts books of sound scholarship and some importance and beauty. So what is the fair use landscape in the US? I don't know much about Australian copyright law or practice. It does go back to Queen Anne, by the way, but once the state laws, the individual colonial laws, were federalized in 1901, I think it was, you've had 4 Copyright Act amendments or changes since then. Australia actually does already have broader exceptions than the other fair dealing countries on one or two things like computer software. And indeed, on moral rights, stronger than the fair use in the US. But anyway, from the little that I have read about it, the fair use debate here, and in Hong Kong too, because it's going on in Hong Kong at the same time, has been centered around the assertion, and I don't mean the Australia Law Reform Commission reduces it to just this, or even the Productivity Commission 600-page report doesn't reduce it to just this. I'm talking about public perception. Reduces it to the assertion that under fair use, everything that's not specifically criminalized is legal, whereas under fair dealing, it's the opposite. Everything that's not specifically legalized is criminal. And so dealing for researchers and universities and libraries and private individuals, fair use then is thought of as a highly socially desirable thing and far preferable. And some proponents say that the American model is modern and is what's needed in a digital age, and some opponents say it will hurt, not help creators, and it will add to complexity and to litigation. So again, what is the fair use landscape in the US? I think the first thing to say is it's not a beacon of crystal clarity any more than is fair dealing. It revolves, as does fair dealing, around factors to be considered. 4 factors: the purpose and the character of the use, the nature of the copyrighted work, the amount and the substantiality of the portion that's used, and the effect on market value. And it's the case law, and it's the precedents, and it's the evolution of interpretations rather than the law itself that are what now shape the copyright landscape in the States. There are indeed legislative changes to the American copyright law under consideration at the moment. Those are largely to do with safe harbors for internet service providers and modernizing the Copyright Office. And over the last 2 years, the House of Representatives Judiciary Committee has held 20 or so hearings about updating copyright law. They're actually being very, very deliberative about how best to update it and the need to update it. It's probably the only area in which the United States Congress is not being completely dysfunctional at the moment. And I think they're doing a pretty good job, and a better job than some governments are. So anyway, fair use in the United States is not a static thing, largely because of this evolving case law, which is, it's true to say, generally in the direction of expansion. The big Google book case was appealed to the Supreme Court, but Google won. Technically, they only won in New York, Connecticut, and Vermont because the Supreme Court refused to hear the case. But that is an expansion of fair use, there's no question. The Georgia State case, which was filed by Cambridge University Press, this is a case about digital course loads as opposed to licensed course loads. That's still going on after 8 years. And the precedents until recently in the States are not really as simple and as broad, I think, as some people think. Until those recent cases, the precedents did, and this is the really boring bit, it's only a paragraph, but to get across the state of fair use in the States, I think I do need to say it. The precedents so far, before these recent cases, did sustain the relevance of impaired actual and potential licensing income to offset fair use. They did declare the need to consider market impact. They did eliminate the purported justifications for internal or private copying. They did reject the notion that socially productive uses must intrinsically be fair use. They did eliminate the claims to per se fair use for certain contexts, and they did affirm the importance of strong copyright protection to social, scientific, and technological progress. Everybody on every side of this debate says that their position is really good for social and economic and technological progress. And all of those precedents were consistent with the Berne Convention and other international copyright treaties. Australia joined the Berne Convention in 1928. The United States didn't join until 1989. That's because we had a protectionist so-called manufacturing clause to protect printers. We've got a really good history, as you probably know, of being incredibly hypocritical when we're lecturing the rest of the world about free trade. But the question that's now been raised and is going on is whether the recent expansions of the fair use doctrine, things like the Google case, are compliant with those international treaties. Google dismisses it by saying that US fair use has been thought compliant, but that's a syllogism because the newly evolved fair use doctrine isn't the same as the old fair use doctrine. It's still not the case, despite what may be said about the flexibility of the fair use doctrine, it's still not the case that text mining is automatically fair use under United States law. And the idea of extending transformative use to any new purpose and to the regularized, non-occasional commercial benefit of entire enterprise is a new thing. And let's put this in perspective. We're all talking here about fair use for the visual arts and the cultural sector. But fair use and transformative use is at the heart of the $9 billion court case that's going on at the moment between Google and Oracle. At the moment, it's sort of 2-1 for Google, but Oracle is certainly going to appeal it all the way to the Supreme Court. And that is a case about whether 11,000 lines of Java code were taken without a copyright fee justifiably under fair use. It's about whether Oracle has to be paid for application programmer interfaces. The astonishing promise of new technologies, unburdened by a vastly extended fair use doctrine, is a very seductive thing to the consuming public. And it's a very seductive thing to jurists and to policy makers. But technology does need content to work its magic. The public increasingly does not see the public benefit of copyright. And it's not just the public. In my own field, the College Art Association, and just 2 weeks ago, the American Association of Museum Directors issued new code of practice fair use guidelines, which are consistent with the precedents and the law, but many see them as an invitation to push towards further expansion. Meanwhile, jurists and policymakers increasingly seem to assume that creative content will continue to be produced with ever diminished copyright. But are they prepared to establish a very vigorous and well-funded state or patronage system to support and create content once copyright is diminished? Where are those replacement systems? If you don't have the strong US tradition of private philanthropy, which governments are stepping in to fund a new patronage system? And I'm just asking that because in the States I've seen a lot of advocacy from the tech sector for fair use extension, but I haven't seen any suggestions from the tech sector about how to compensate creators other than a sort of blame the victim approach. If your content is pirated or seized, well, change your business model. At least we have private philanthropy and tax laws supporting private philanthropy to encourage that. What do you have to take up the slack? It's true that courts have generally sided with tech companies versus content creators. That does seem to the way fair use extension is going, but there's a lot of litigation. Okay, so that was the boring stuff, and I see I bored a couple of people. So what's going on now around the world? I did prepare a survey of what's going on around the world, but there isn't time to go through all that. So I'll go straight to the EU, actually. If anyone has questions on some of these other individual countries later, and if there's time, I'll answer them. But in Europe, legislation has been postponed from June till September. And a very fierce and biting attack recently on what he calls the European Commission's senseless assault on copyright by Arnaud Nouri, he's the CEO of Hachette, has thrown up some serious opposition to tech-driven legislative change. The rallying cry, "Google prevailed in the US but not in France," it's quite appealing. It's quite powerful, as is the reframing from defense to attacks on tech companies' strategy of building their businesses by using publisher content as loss-making free products to support an advertising business. In France and Germany, there are new proposals, but they're largely ones intended to help authors and artists and other creators. South Africa does look as if it's moving to fair use, but it's a bit confused. There are two competing bills in Parliament there on indigenous use. Not sure which way that's going to go. Switzerland has a draft copyright amendment bill with a fair use exception for text and data mining, but there's a lot of public consultation going. They're not rushing it through, as is South Africa. That probably won't happen until 2017. I'm going to skip through Latin America. I'm going to skip through the Middle East. I will stop at Canada, because Canada is always mentioned as the big warning for Australia. Canada is actually still fair dealing. It's not a fair use country. There are only 4 or 5 fair use countries in the world. But in 2012, there were 5 Supreme Court copyright decisions that went against copyright owners, and Canada amended its Copyright Act to add the word education to exceptions. And the estimates of lost revenue to small to medium-sized publishers are generally about $50 million. What happened was that educational institutions which had been paying licensing fees stopped paying them in 97% of cases. What has certainly happened is that Oxford University Press Canada has stopped publishing Canadian materials for Canadian schools. More schools are having to rely on imported American textbooks. And Broadview Press, which published Canada-focused anthologies like native poetry in Canada, has stopped publishing such titles. I'm not sure if they've actually gone out of business, but certainly the indigenous part of their list has ceased. Singapore did introduce fair use in 2005. Some extolled it as something that would encourage artistic creativity, and a paper in 2014 said that it had resulted in economic gains, but they were economic gains for industry segments that facilitate private copying. There didn't seem to be any evidence that there was more creation of new transformative works. What undoubtedly did happen in the 10 years since they introduced it was that there was a surge in piracy, to the point that 9 years after they legislated fair use, they had to amend the Copyright Act to address widespread digital piracy. There's a new paper published this year, just in February, that seeks to debunk quite scathingly the previous paper's economic assertions. Finally, New Zealand. We all had our favorite flag candidates. This one was mine. There's a mandatory copyright review on a regular basis, I understand, but it's been put off owing to the issues around accession to the Trans-Pacific Partnership. But I think the main issue there has been whether or not to extend copyright from 50 to 70 years after the death of a creator to harmonize with most countries, at any rate. Of course, the Australian Productivity Commission's report, as you will know, flirted with the idea of reducing it to 15 years, although I think that's now been scotched. As I said, I'm not qualified to talk about the differences between the positions of the Law Review Committee and the Productivity Commission and the Australian Digital Alliance and the other reports out there, the Ernst & Young one and the PricewaterhouseCoopers one. I do know that some of the things lumped together in those reports, like personal use and caching and cloud computing and data mining and other innovative uses lumped together, are by no means all the same things in their economic effects. And I do know, too, that it's generally unhelpful when complex issues get reduced to simplistic outrage. The way issues are framed does make a difference. Pretty much everybody agrees that copyright law lags technological change. Pretty much everybody knows that minimizing individual transactions and tedious, unproductive labor is eminently desirable, and that a simple small claims process for infringement might be a good thing. But I sometimes think that even the phrase copyright reform is a bit loaded. I'd rather use copyright modernization. Okay, how does all that boring stuff I've talked about in the first two parts relate to visual arts practices? What are the opportunities and the challenges for artists today in all of this? The sources available to artists now are so disparate and so widely spread across different media. The electronic superhighway envisaged by Namjoon Paik in the last century has long been with us. The Whitechapel Gallery has just concluded a show with that title, Electronic Superhighway, covering 50 years of media art. And it runs all the way from Namjoon Paik's video art in the 70s to this piece called Surface Tension by Rafael Lozano Hema, which is a theatrical interactive installation whose eye tracks the viewer and opens and closes as it senses your body heat. Art and the internet is all about linking and borrowing and collaborating. The juxtaposition of real and virtual, the juxtaposition of analog and digital inevitably involves linking and appropriation. Whether it's Corey Archangel, blurring drawing and music and video and performance art and video game modifications, or Douglas Copeland playing with facial recognition technology, or Celia Hampton painting while in an online chat room, or Ryan Tricartin doing video plays and video art, which is inextricably linked to the internet. It all now involves our post-YouTube, post-Instagram, hyperlinked world, and our hyperlinked minds. That's where we are now with computer art, with video art, with internet art. But as the artist, you are in control. You or your designated representative. All of these complexities and pitfalls that I've been rabbiting on about are yours to control when it comes to your own work. You can disseminate your own work as broadly or as narrowly, as universally or as secretively as you want. To be sure, appropriation may mean you have to take some care if you're engaged in appropriation art. But as a practical matter, lawsuits tend to be filed against organizations perceived as having deep pockets, rather than against individual artists. And the current emphasis, whether in fair use or fair dealing, on transformative use helps artists. It really helps artists too. Public domain work is anyway safe. You can do what you want with the Mona Lisa. You're perfectly safe with Vermeer. And even though the copyright agency that handles the Grant Wood estate vigorously maintained that American Gothic had not fallen into the public domain by virtue of the estate not having renewed copyright, which you used to have to do in the United States when registration was still required. Grant Wood may be long enough dead now that it's all public domain, I don't know. But I never heard of any transformative or parody version of American Gothic being questioned. I was going to say the only one recent artist case I could think of, which I'm going to talk about right now, but Melissa reminded us there is the Graham Richard Prince case as well. But the one case I was going to talk about that was litigated was of the Shepherd Fairy Hope poster. Fairy created this design and then he sold it as a poster, and it was widely distributed during the 2008 election campaign, which of course now seems like a prelapsarian golden age of gentleness and civility. Anyway, in 2009, Associated Press claimed compensation for the use of the photograph on which, it was an Associated Press photograph, on which the poster was based. Fairy wasn't sued. He actually sued for a declaratory judgment to say it was fair use. And there was an undisclosed, this is another thing about the American system, there was an undisclosed out-of-court settlement in 2011. But there was a separate issue, not to do with fair use. When Fairy sued, he sued after AP had said the poster was based on its photo, and he claimed he'd used a different photo. But in fact, he was wrong. And he tried to hide that. He tried to hide the error by destroying and fabricating documents. And it was for that, in 2012, that he did plead guilty and was fined $25,000. So I was going to skip in the interests of time, but a couple of people yesterday said, do talk about this. It'll only take a couple of minutes. Sanja Ivekovic is a Croatian artist who deals with issues of female identity and consumerism and media and political strife. And these are works from a show and a book we did of her work, which was called Sweet Violence. So there is appropriation here. There's defacing or manipulation of pages from women's magazines. There is superimposition on models' images of the names and fates of other women killed by the fascists in World War II, which of course was done without the permission of the models or the publishers. And then a step further, there's the very overt imposition of text that tells the stories of marginalized women, printed over consumerist ads that not only depict completely unrelated models, but that also depict the brand names of the luxury goods or fashion corporations that were advertising in the magazines. Nobody, to my knowledge, ever voiced any complaint to the artist, and I doubt she ever considered any legal ramifications, though I'm quite certain she intended to ruffle some corporate feathers. But for us, it was an issue. We had to think very hard about whether one of the corporations involved might object to our publishing the works. And we did think very hard, and in the end we made a business decision to take the risk. Actually, concerns about risks in appropriation in art are hardly new. Giulio Romano, this is Titian's portrait of him, he moved from Rome to Mantua in 1524, and he began work on a series of erotic paintings entitled I Modi, the Positions. And they were copied by the engraver and publisher Marcantonio Raimondi, who published them in a 1524 edition. This is the first edition was destroyed. This is a later version by Carracci, but you get the idea. They were very, very explicit for their time. Meanwhile, Raimondi was also known for having made copies while he was in Venice of Dürer's woodcuts, and particularly of Dürer's series, The Life of the Virgin. So poor Raimondi, he ran into a lot of trouble on two fronts, because Dürer didn't like his work being copied, and he complained to the Venetian government, and the Pope didn't like the dirty pictures, and he wanted to do something about that. But it's interesting how the cases got resolved. The Venetians did not stop the copying of Dürer's work. They just said, you can't use his monogram. And I guess that's early trademark protection. That's sort of early evolution of intellectual property law. So Raimondi got away with that one. More serious was the case against the Romano images. But the Pope didn't go after the artist. He went after the publisher on the grounds, not of obscenity, although that's what he was concerned about, but on the grounds that this was illegal copying of Romano's work. And Raimondi did get locked up in prison. So I guess, again, the moral is the artist doesn't have as much to worry about as the publisher does. As an artist today, your sources are wider, your ability to appropriate is easier, but at the same time standing out in a time when everyone can be an artist almost, and when technological work is aging fast, and when, as we've heard, art can be just an algorithm and everybody has to use Instagram or some such media, it's more difficult. You can do what you want in terms of control, but as we've heard, what should you do? I'm a great believer in the efficacy of these non-exclusive licenses, whereby you are generous about relatively non-commercial exploitation that gets the word out, while retaining control on quality and the things that really matter to you. But people will always look after their own interests as they perceive them. We're engaged at the moment in a big retrospective of Robert Rauschenberg. It's a co-organized project between MoMA and the Tate. In fact, the show will open first at the Tate this November, but we're doing the book. And we're still playing around with the design of the book and the cover. It might be something like this. It might be something like this. But it's an interesting example of a different approach taken by an artist's estate, in that they have just this year decided to make Rauschenberg images much more widely available for free. And they're giving up a significant image rights income to do that. It's neither right nor wrong, that decision, but it was their decision to make. They made that decision based on what they perceive as their best interest in furthering Rauschenberg's legacy and scholarship, and whether or not these particular uses would be fair use, they're okay with them, which isn't to say they'd be okay with any commercial use. As I said, and I'll probably say again, Tim, artists rarely get sued. And now this is a tangent, actually, about a different sort of appropriation, but involving Rauschenberg, but it's an interesting one, I think. I show you here the cover of our book about one of Rauschenberg's combines. These are works that he did that incorporate painting and collage and found objects. In 1959, he made this piece. It's called Canyon, and it includes a stuffed bald eagle that a neighbor of his found in a pile of discarded belongings in the hallway of the Carnegie Hall studio building. Rauschenberg sold the work to the gallery owner, Ileana Sun Oven. Now, the Migratory Bird Treaty Act of 1914 and the Bald Eagle Protection Act of 1940 make it illegal to buy or sell or possess a bald eagle. But Rauschenberg provided a notarized letter that said accurately that it was one of Teddy Roosevelt's Rough Riders that had stuffed the bird in the first place before the laws existed. So Sun Oven was allowed by the US Fish and Wildlife Service to keep it. But then in 2007, she died. Now the heirs would be committing a felony if they tried to sell this work. So the appraisers valued it at 0. But the IRS, the American Tax Authority, valued it at $65 million. And they demanded $29.2 million in taxes. But the heirs couldn't legally sell it in order to pay the taxes. So then the IRS said, well, we're adding $11 million because you haven't paid. It's $11 million penalty on top of the $29.2 million. And there was this standoff that went on until 2012, when a resolution was reached by which the tax claim was dropped in return for the work being donated to a public art museum. And that's how it came to us, and that's how we came to publish the book. This is an 1880 Jacob Riis photograph of reporters in Lower New York who, despite working fiercely in competition with each other, are bonding together, cementing relationships over their card game. And I like the image because whether it's the ecosystem that serves artists and distributors or the ecosystem that will underlie what comes next in visual arts publishing, it reminds us that human relationships often trump one's legal rights. I could tell you of many instances where we have elected not to push fair use, or we have elected to make an unrequired gesture of goodwill and found it to be the best business decision possible. I call it the Chivas Regal approach because it was a crate of Chivas Regal. That is what led me to a definitive rapprochement with a great photographer's widow and avoided a lawsuit. So finally, I'm getting near the end, I promise. Finally, what is next for visual arts publishing? I'm rather fond of the Gartner hype curve. Gartner is a consulting firm that each year measures technological change on a graph that moves from the technology trigger in the lower left up to the peak of inflated expectations, then down to the trough of disillusionment, which is followed by a slow and modest slope of enlightenment until finally you reach a mature and generally rather low-lying plateau of productivity. About 8 years ago, ebooks and especially the Kindle were right at the top of the curve. And we, like everybody else, jumped in and invested significantly, but before we realized that it was going to settle down to a very modest, especially for art books, a very, very modest level. If anyone's interested, here's the most recent hype curve. The Internet of Things is right at the top of the curve. Wearable technology are beginning on the precipitous descent section, and augmented reality is near the bottom of the trough of disillusion, but it is beginning to climb out. I don't have a clue how it will all shake out. The only thing that I know for sure is that the futurologists always get it wrong. You probably expect me to talk about the next thing in digital publishing, and I could talk about some of those initiatives, but this is not a talk about products, and anywhere we're short of time. So I'm just going to give 5 thoughts on this, and then we're done. First, beware of people like me lecturing at conferences. Especially beware of people who seem to be telling publishers what to do rather than actually doing it. It's easy, if you're paid by a tech company, to pontificate about what the future of publishing needs to be. Right now, the conversations with governments are disproportionately controlled by the tech sector. Google, Amazon, Facebook, and Apple have very, very good lobbyists, and their lobbyists get a lot of attention. But also, more subtly, it's easy to pontificate about what creators should do if you're paid by the government. But if your business model has been or is being destroyed and you still want to create good content, you've got to find a new way, and you've got to find solutions, and you've got to find funding. That's what you need. You don't need lectures from people who aren't creating content. Secondly, from the consumer point of view, the consumption of publisher content is increasingly messy. It's gloriously messy, actually, and I think we should accept this and revel in it. The means of consumption are changing. E-books were really about devices as much as they were about content. Everyone reads now on every sort of device, as well as on paper. But e-books offer little new except convenience. Digital publishing as a direct revenue stream has actually not been very exciting. And in fact, most new products from the content point of view have been disappointing, in my view. The digital culture of free and of piracy has perhaps inhibited some developments, but that's only one reason why the landscape is littered with dead experiments and failed shared reading experiences. As consumers, we really don't care about anything except convenience and price and a pleasant experience. In some contexts, we will want portability and audio and video, but we will reject excessive, intrusive video jumps and incessant advertising. But sometimes we want unshared communication and the gloriously one-way street offered by a take-it-or-leave-it book. Our consumption is now gloriously hybrid, and that's what we want. And for the arts, and for arts publishing, print does remain an important component of that. Arnaud Nouri, I quoted him before, the French CEO, he recently said that the production mechanisms for wine haven't changed much any more than has the physical appearance of the book, but no one is holding conferences about the future of wine. That's perhaps a particularly Gallic observation. But there's something to it. He said the same thing about wheels and spoons. The technology has been around forever, but we don't have conferences about the future of wheels or spoons. That's my second point. The third point is we need to recognize that the current disruption is not a sudden thing. It began a long, long time ago, and it will go on for a long, long time. Publishing production started being disrupted 20 or 30 years ago as we dispensed with camera copy and metal type and with film. And now it's the marketing and the dissemination and the distribution that are being disrupted. But it's a long-term disruption. And this is great. We're maybe now in our 100-year cycle of disruption at about the equivalent of, 1475 maybe. And that's a stimulating thing, I think. The thing to do is to remember why we're doing what we're doing and not get too hung up about where we are in what is undoubtedly a long-term disruption cycle. But fourth point, the road to hell is paved with good intentions. Be wary of the well-meaning good guys. Open access offers great benefits in accessibility and in geographical distribution around the world, but too many people don't understand that it has to be paid for somehow. How many advocates of open access mandates have really looked into the gold, green, and platinum open access models and really understood the funding needs of each of them? To too many, and this is where I offend the people in the audience that I haven't already offended, to too many people in Western universities, Alexandra Elbakyan, she's the lady behind Sci-Hub and LibGen. If you don't know about them, I'll explain them. She's a folk hero. She's a Robin Hood who has enabled them to have downloaded for free 28 million research papers. But that sort of open access cannot be the future of scholarly publishing for the simple reason that in the long term, no one will create content in the first place if it's just going to be stolen and if it isn't funded. Elbakyan has been convicted by courts in both the US and Israel, but pirates will always do what pirates can do. It's not so much that concerns me, it's the fuzzy thinking of the enablers that I think should be of equal concern. It's our dear colleagues in library systems who have access to the library credentials, who enjoy the free ride and think it's okay to download something and disseminate it as widely as possible. I completely understand why slashed library budgets have led people to, of necessity, love free content. But I actually think the removal of the need to purchase, which has been forced on everybody by these budget considerations, has in fact removed a valuable selection criterion. In my field of museum publishing, we have the situation where permanent collection catalogues have largely migrated online. And online, of course, it's no longer supported by book purchases from libraries and institutions and collectors and galleries who, in the case of those last two, could still afford it. Instead, it's supported by the generosity of just two philanthropic sources. The foundation set up some 35 years ago by the trustees of the will of the oil magnate, J. Paul Getty, and the foundation set up 46 years ago by the descendants of Andrew Mellon, who made his money in industry and banking 100 years ago. Now, of course, it's great that that support exists, but it's not a particularly healthy state of affairs. In a way, it's a reversion to a 17th century patronage system. And I'd have thought it would be of particular concern for places and for countries that don't have the really strong philanthropic tradition that we do have in the United States. So here's what I find myself saying to my well-meaning, progressive, serious-minded colleagues in museum publishing. You want to compensate creators and artists' estates and film companies, and you want to be above any criticism in being a Medici. And that's great. That is so noble. It really is. I mean that. It's a noble goal. And at the same time, you want to be a force for good in the world, and you want to bring art to as many people as possible, and at the highest levels of design and quality and scholarship, while also at the greatest level of accessibility. And that's equally great and noble, and I mean that as well. But if your business model now is essentially to buy high and then give away for free, all that nobility is just nobility of purpose. It's not nobility of achievement. You need to have sustainability. But these don't just have to be gloomy existential questions for arts publishers. I think you just have to distinguish between creative disruption and destructive disruption. And you just have to seize control of some of the narrative instead of being defensive. And that's my fifth and final point, which is to not focus on where we happen to be in the disruption cycle, focus on why publishers do what we do. We don't do publishing because we're engineers trying to design or sell an engineering solution to a problem that may not exist. We don't generally go into publishing to make money. Our motivation is primarily cultural rather than financial. Publishing has always been between the stock exchange and the cathedral, as Thomas Carlyle said. It's always been between God and mammon. We do have to be nimble in new ways. We do have to be adaptive, but not abandon principles. If a customer won't pay in the old way, I'll sell another way. I'll get it paid for another way, but I'll still create quality content because that's what I do. I care about publishing good books, sound scholarship, beautiful design, things that I hope add to knowledge and bestow some pleasure. And I think if you keep that focus, if you push aside the distractions of the ephemeral software solution of the day, the future of that sort of arts publishing is quite solid. Not the future for outmoded distribution systems, but the future for creating good content is quite rosy for several reasons. One is comfort about the sort of hybrid publishing that's emerged that I've described, that uses digital to support what's still a strong physical print publishing program. Another is the resurgence and strengthening of the independent bookstores that weathered the last 10 years, places where content can garner revenue. A third reason, I confess, is specific to MoMA, the physical expansion that comes in 2019 with the completion of the new super tall tower, which will add 40% to our existing gallery space, and I'm quite sure will add to the 3 million visitors that we already get today, which is a very healthy number passing through our bookstores. And a fourth reason is the undoubted strengthening that we've seen in the last year or two of the market for quality hardcover books. This actually is a cultural shift as much as a market phenomenon. There is a renewed confidence, as I've said, among both readers and publishers about books. The only caveat is that we, on the creative content side of things, just need to seize control of some of the narrative, of some of the issues of the day. We need to say that there are some babies in the bathwater, that regulation is not a bad word. When the thinking in the public debate is fuzzy, or when the cultural sector is too much rocked by the tech companies agenda, we do need to speak out. And we don't frame this as the old guard denying progress. We frame it as requiring legislators and regulators to adapt, just as we have had to adapt. It's not old-fashioned or outmoded to demand and to insist on good new regulation in an unfettered environment. Quite the contrary. New times demand a new regulatory environment. And that's true whether the issue is taxation in a global economy or intellectual property in a newly digitized world. So in sum, all we need to do is remember that there's no such thing as a free lunch. Thank you.